So I'm just going to briefly talk to you about intellectual property. Given the fact that you guys are going to be having a very short and brief presentation, I don't think it will affect you that much. But just in case somebody is out there wanting to reveal everything about everything, you just should be aware that what you're doing here, it's considered a public disclosure, and that means that you may be revealing too much, and that means that you'll be forfeiting your right to have your ideas protected. So I'll be talking a little bit about each and every one of the statements I just made. So basically, I'm just going to give you an overview about the IP basics. IP meaning intellectual property. What is intellectual property? Who owns what? And what is public disclosure? Basically, the idea that you go outside and you tell your idea and your invention. And a quick overview of the Technology Transfer Office of the university. All right, so what is intellectual property? Basically, it's what the statement says, is anything in your mind, anything in your head, everything you create. It could be invention, something you work at the lab. It could be literary work. It could be a song that you invent, a music, a melody, a design, anything that can be used in commerce. So the government basically came and said that you guys, you should capitalize on this, and intellectual property has value, so I'm going to create mechanisms to protect intellectual property. And usually those are done through patents, copyrights, trademarks, and trade secrets. And I'm going to briefly go through each and every one of them. So what are patents? Patents, especially for people in the sciences, are the most common mechanism and tool to protect your idea or your inventions. This is a right granted by the government to exclude others from making, using, or offering for sale your idea in exchange for you disclosing publicly your invention. So it becomes at some point a public good, something that everybody wins from. So note, exclude others. Basically, the government does not go after others to, protect your idea. You have to do that, but the government offers you a way to do that through the court system. So there is a separate patent court system that you can go to and get your idea enforced. Now, there are three types of patents: utility, design, and plant. Utility patents are usually the most common of the patents, are inventions that discover new processes, methods, articles of manufacture, compositions of matter, and everything. The most common example is an Audi engine, just something mechanical put together that serves a purpose. A design patent is, for example, something that gives a design, something specific that you can use for commerce. The most commonly known is the Apple iPhone design patent that everybody else tried to copy and Apple tried to enforce somewhat unsuccessfully. And another patent is the plant patent, for example, like climbing rose, something that is that you could cultivate asexually, that is not found in nature. So we're going to get to that. You cannot patent things from nature. So what are the requirements for getting a patent, especially utility patent? It has to be novel. Basically, it cannot be found out there. Somebody cannot disclose it in a journal article, cannot display it in a conference, cannot have a prototype of them. You cannot show it to the public. So if somebody has done that, they have their idea before you. It has to be non-obvious, and this is the most controversial term out there. So somebody in your field cannot just think of multiple things together and replicate what you've done. So you have to sort of think of something that your colleagues haven't thought of. And usually this is where we get a lot of rejections. And it has to be useful, obviously. This is a patent that is somebody just wanted to patent it so that they can show that they could patent anything. After this patent went through, they changed the law to have that usability aspect to it. So something that is useful to society and just not like a game like that. What are copyrights? Again, for people in the sciences and for people that do research, your most common copyrighted material would be a journal article, something that you publish. It could be books, theatrical works, oral presentations, drawings, paintings, designs, anything that requires your creativity. Now, For people that works in the sciences and the arts, your copyrights usually are engaged in a university setting. Usually copyrights are your own unless you assign them to the university or the university commissions you to do them, to make them. Trademarks, you probably are very, very familiar to them. They're basically marks that identify a business or a service, and you're probably bombarded with them everywhere you go. Trade secrets, again, you sort of are familiar with them, are confidential business information. They can be manufacturing, industrial, commercial, which gives you a competitive edge, but if revealed, somebody else could copy easily and sort of scoop you out. So the best idea is not to disclose them publicly through a patent or a copyright, but to keep them secret, and you do all sorts of shenanigans to keep them secret. The most common shenanigan is, the KFC secret recipe in a vault in some really, really famous bank, and they moved it from one place to another, and they had half a city police to protect that recipe. But it's that valuable, that useful, and it brings a lot of profit to the company. So of course they're going to protect it that way. Now, when it comes to, again, we're talking about the university setting. There is a common distinction between an inventor of a patent and the owner of the patent. Since you guys are all here, and if you work in research, especially in the STEM areas, then you can be inventors in a patent. Don't confuse it with authorship. So you can be an author in a publication, but not necessarily an inventor. An author is somebody that does a contribution to a publication. For example, let's say it runs a lab protocol and just follows the rules and gathers the analysis, but doesn't necessarily contribute to the idea behind, let's say, that particular research. It's the person that finds an inventive step, somebody that creates a new design, a new model, a new process to make that idea better. Usually those are considered inventors. The owner is generally the people that commissioned you to create that research. For federally funded research, generally that is the government has certain rights, but the owner is the university. So if the university pays for your salary, if the university allows you to access high-tech equipment, allows you to access faculty, and you come up with an invention that, well, the university will have rights to that invention and will generally own it. So how does it relate to you? As I mentioned it a little bit, you may be directly involved in creating intellectual property. Most of the times, that intellectual property can be protected. So if you're a student working in a lab, generally the university will own that intellectual property. But if you're a student that is sort of using university resources as part of their coursework, or just a computer lab for just basic use, then usually the university will not own that. There is a board policy for that, because we do not want to be seen as somebody that just wants to take the students' intellectual property and monetize it. We want to encourage it. And that is the reason why we have specifically put this policy in mind, so that students can continue their entrepreneurial pursuits without having the university interfere. Again, so let's say you're an inventor in a potential patent. So what's in it for you? Why would you even want to bother to do some research? Well, the universities are generally generous when it comes to this. They usually share the revenues. So let's say we file a patent where you're a co-inventor, and that patent goes and gets licensed to a large company. The large company starts paying revenue to the university. Well, the university doesn't want to keep that revenue all for themselves. They want to share with you. So our board policy is that 50% of the first $200,000 that comes as revenue to the university is split 50-50, and then 35% of that revenue goes to the inventors afterward. Again, if you're a faculty or even a student, you can also own equity in a spin-off company. So the university doesn't prevent you to own a spin-off company and license your own technology from the university. It doesn't forfeit any royalty revenues. You can be a CDO for your company, and that is generally mostly for faculty. And you have to be aware of the conflict of interest and conflict of management of time so that you don't basically overstep your duties as a professor or as a student. Now this is our tech transfer process. We just do an invention disclosure process. We have an assessment on it. We protect it through basically our legal team, and we try to commercialize it. It's a very long process. Most of the time is unsuccessful, but if one of our patents hits, then hopefully we'll have more people engaged in this activity.
Apologize about that.
Oh, no worries. All right, let me
try that one more time.
All right, and we'll go. So, since you're going to be involved in public disclosure, you should know what it is that you've given up if you tell your secret sauce and your secret recipes to others. Basically, you give up your right of your invention for being protected. So, if you, let's say, go out there in a conference and you present all your data and you present all your research and you show how the methodology of the process, let's say I need 120 milligram of this and we can have, this secret process is made and all of that, and you haven't filed for a patent protection 1 year prior to, 1 year after you've done the disclosure, then you forfeit your right to patent protection. So you have to be very aware of that. If you think that you have some research that you think may have commercial value. Now, the key word here is to have to whenever you do public disclosure, now to have enabling information. What do I mean by enabling? Enabling meaning that you show somebody else how it's done. So if you go to a conference and you display and you disclose your information to somebody in a way that they can go back to their lab and do exactly the same thing and get exactly the same result as you, then you've just shown they enabled somebody to copy your research, basically. So if you've done that without protecting through a patent, then you lost that right to basically commercialize it. So again, this is just a laundry list of what constitutes a public disclosure. It can be, journal publication, even the 3MT if you guys are not careful enough. You can just demonstrate a prototype, try to sell something. So even if you sell your invention without having it protected, then you still lose the right of patenting it. So how much detail that you need to do? Again, as I mentioned before, just don't mention the secret sauce. Just sort of keep it very vague and a bird's eye view, so that show the benefits and what the invention does, but not how it does it. And you can show how it does it if you have the appropriate confidentiality agreement, and even better if you have a patent or a copyright or something else filed. It will protect your intellectual property. So again, just to reiterate, the best way to manage public disclosure is just be general. Don't disclose information that can be enabling. Better yet, file a patent before you actually go ahead and publish or present in a conference. So there is also another way to do it, is that you could potentially publish your research. You have 1 year of having the patent filed per US law. However, you forfeit your right to file for foreign patents. So you basically limit your market only to the United States. So, and questions? If you have anything more specific, you go back and you think about something that you want to do. Have my cards with me, so you can reach me, call me, email me, come and see me, and I can sit down with you and we can go over your specific slides. And if you think you're revealing too much, I'm more than happy to help